Picture this. The year is 1974. Two researchers, Amos Tversky and Daniel Kahneman, are about to conduct an experiment that will forever change how we understand decision-making, not just in everyday life, but within the hallowed halls of justice. They gathered a group of participants and presented them with a seemingly simple task. A wheel of fortune, much like the ones you might see on game shows, was spun in front of them. But this wheel was rigged. It was designed to stop only on either the number 10 or the number 65. After the wheel stopped, the participants were asked two questions. First, they were asked if they believed the percentage of African countries in the United Nations was higher or lower than the number they just saw on the wheel. Then they were asked to give their best estimate of the actual percentage. You might think that the random number on the wheel would have no impact on their estimates, right? After all, what does a game show wheel have to do with the composition of the United Nations? But here's where it gets interesting. The results were striking. Participants who saw the wheel stop on the number 10 provided significantly lower estimates, averaging around 25%. On the other hand, those who saw the wheel stop on 65 gave much higher estimates, averaging around 45%. A completely random, irrelevant number dramatically influenced their judgments about a completely unrelated question. This, my friend, is the anchoring bias in action. And it's not just a quirky finding from a psychology experiment. It has profound implications for how justice is served, or perhaps misserved, in our legal system. Think about it. In a courtroom, decisions are made every single day that impact people's lives in profound ways. Settlement amounts, sentencing lengths, liability, judgments, all of these are susceptible to the very same anchoring bias that Tversky and Kahneman demonstrated. The first number put on the table, whether it's a prosecutor's initial plea offer or a plaintiff's initial damage demand, can act as a powerful anchor, pulling the final outcome toward it, regardless of whether that initial number is reasonable or even remotely connected to the facts of the case. Now you might be thinking, but surely judges and lawyers with their training and experience are immune to these kinds of biases, right? Well, unfortunately, the research suggests otherwise. Numerous studies have shown that legal professionals, just like the rest of us, are vulnerable to the anchoring effect. One particularly compelling study involved experienced judges. These judges were presented with a hypothetical legal case, complete with all the relevant details. The only difference was the anchor they were given. One group of judges was presented with a low anchor, a demand from the plaintiff's attorney that was clearly too low. The other group was presented with a high anchor, a demand that was clearly excessive. The results? The judges exposed to the high anchor awarded significantly higher damages than those exposed to the low anchor, even though the underlying facts of the case were identical. The initial demand, even one that was demonstrably unreasonable, exerted a powerful influence on their judgments. And it's not just judges. Jurors too are susceptible. Imagine you're sitting on a jury listening to a complex case. You're trying to make sense of all the evidence, the arguments, the legal jargon. Then the plaintiff's attorney asks for $10 million in damages. That number, that enormous sum, becomes an anchor in your mind. Even if you consciously try to disregard it, it's there, influencing your perception of what a reasonable amount might be. Subsequent arguments and evidence are then interpreted through the lens of that initial anchor. Let's consider another real-world example. Think about plea bargains, which account for the vast majority of criminal cases in many countries. The prosecutor's initial offer often sets the stage for all subsequent negotiations. If the initial offer is high, the final plea agreement is likely to be higher than if the initial offer had been lower, even if the strength of the evidence is the same in both scenarios. This isn't necessarily a conscious, malicious manipulation on the part of the prosecutor, although that's certainly possible. It's often simply the anchoring bias at work, influencing both the prosecutor's and the defendant's perception of the case's value. So what are the ethical implications of all this? Well, they're significant. If justice is supposed to be blind, if decisions are supposed to be based on facts and evidence, then the anchoring bias presents a serious challenge. It suggests that outcomes can be influenced, even manipulated, by factors that have nothing to do with the merits of the case. This raises fundamental questions about fairness, impartiality, and the integrity of the legal system. Now, you might be asking yourself, is there anything we can do about this? Are we simply doomed to be victims of our own cognitive biases? The answer, thankfully, is no. There are steps we can take to mitigate the impact of anchoring in legal settings. One approach is awareness. Simply knowing that the anchoring bias exists can help judges, lawyers, and jurors to be more mindful of its influence. By consciously recognizing the potential for this bias to creep into their decision-making, they can take steps to counteract it. This might involve actively questioning their own assumptions, seeking out alternative perspectives, and focusing on objective criteria rather than being swayed by initial numbers. Another strategy is to use mediators. In settlement negotiations, for example, a neutral third party can help to guide the discussions and prevent the parties from becoming overly anchored to their initial positions. The mediator can help to establish a more realistic range for negotiation and facilitate a more objective assessment of the case's value. The way information is presented can also make a difference. Studies have shown that presenting information in a more neutral or balanced way can reduce the anchoring effect. For example, instead of starting with a high or low demand, presenting a range of possible outcomes or focusing on the underlying principles of fairness and justice can help to minimize the influence of any single number. Furthermore, legal education and training can play a crucial role. By incorporating training on cognitive biases, including the anchoring bias, into law school curricula and continuing legal education programs, we can equip legal professionals with the tools they need to recognize and address these biases in their own practice. It's also important to remember that the anchoring bias is not unique to the legal system. It affects all of us, in all areas of our lives. From negotiating the price of a car to deciding how much to offer for a house, to even estimating how long it will take us to complete a task, we are constantly being influenced by anchors, often without even realizing it. The key takeaway here is that our minds don't operate in a vacuum. We don't make decisions based solely on objective facts and rational analysis. Our judgments are shaped by a variety of cognitive biases, and the anchoring bias is one of the most powerful and pervasive. By understanding how this bias works, and by taking steps to mitigate its effects, we can strive for a more just and equitable legal system and make better decisions in our own lives. It's not about eliminating bias entirely. That's likely impossible. It's about recognizing our inherent limitations and striving to be as objective and fair as possible despite them. It's about acknowledging that even the most experienced and well-intentioned among us are susceptible to these cognitive quirks, and that vigilance and self-awareness are crucial in the pursuit of justice. The pursuit of justice should always be grounded in evidence, reason, and a commitment to fairness, not swayed by the subtle yet powerful influence of a randomly chosen number. The experiment from 1974, with its rigged wheel of fortune, serves as a constant reminder of the fragility of our judgment and the importance of striving for objectivity in all our decision-making, especially when the stakes are as high as they are in the courtroom.